Meeting of the Michigan State Board of Canvassers is called to order at 10 a.m. Good morning. First order of business is public comment. Is there anyone? That's a no. The consideration of the meeting minutes for the October 17th, 2025 meeting. I need a motion.
So moved.
All in favor?
Aye.
Any opposed? No. We have a consideration of the proposed procedure for the circulator signature challenges. I'd like to turn this over to Director Brader to introduce that.
Thanks, Chair Housekamp. So this is a process that we've been engaged in since the last election cycle, the presidential election cycle in 2024. As the board, I'm sure knows, we had some challenges to the validity of the signatures in the circulator box for candidate Cornel West. The BOE and the board are quite familiar with the process and well-versed in handling challenges to the signatories, the signers of the petitions. But this involved an allegation that the actual circulator signatures were not valid. So not having an established process to handle those in 2024, we didn't really engage with those types of challenges. We focus more on the validity of the signatures of the petition signers. Ultimately, that petition was approved, and then there was litigation after the fact. Court determined that the board has discretion, but it does need to investigate these allegations. As the board knows, we did quite a drawn out process, trying to evaluate, getting exemplars and evaluating the signatures in the West petition. But that remains, the question remains is what we will do for this upcoming election cycle when we inevitably get more challenges to the validity of the circulator signatures. So we've had a couple of rounds of this procedure. I've gotten some feedback from the board and from the public. And so what you have before you is the product of that, which is what the Bureau is proposing, be the procedure that the Bureau of Elections follows when it receives challenges to circulator signatures, and then what the board will then do considering those challenges following BOE review. The goal is to have a process that everybody understands at the front end, that we can apply so that we can handle these challenges as they come during the very short window we have for petition review. Adam, is there any? Oh, sorry, go ahead. Okay, Adam, is there anything you wanted to add for context?
I'll just talk about for a second the couple of changes. They were relatively minor with the changes that we made, but we went through and attempted to clarify the procedure side of things. So if you remember from the last meeting when we talked about this, the biggest thing that I think that I need to know is basically what the board wants us to do procedurally when a challenge comes in. And so what we added was right on page 1, there's a best practice right away when candidate submits petitions, where we added the best practice of if you're using a circulator who is not registered in the state of Michigan, registered to vote in the state of Michigan, or if they are all outside of the state of Michigan, if they reside, that it is a best practice that you get some sort of exemplar from that and have it ready to go. So that way, when we ask about it, we are able to just have it and it can speed up the process. So for the most part, that honestly is the only change that was made. I think we corrected a few other minor throughout, but substantively, that was the only, that was the biggest change that was made in from the last version to this one.
Thank you, Mr. Chair. Mark Brewer of Goodman Acker. I'm here in my personal capacity today. First, I want to apologize for not getting comments in last week. I've been a little busy with an election in Hamtramck that you may all have heard about. So, but I do have some comments today to share with you. The first is that I'd like to confirm that these procedures will also be applied to challenges to circulator signatures on ballot proposal petitions. I expect there are going to be ballot proposals filed this cycle, and there may well be challenges to those circulators. And so I think it'd be an excellent idea for this board to have procedures in place. It seems to me that these procedures, with a few changes, for example, challenges to ballot proposals are due within 10 days of the disclosure of the sample as opposed to 7 for candidate petitions. So I have one other substantive comment on these, but I just really think it's important that the board plan ahead. You may get circulator challenges to ballot proposals, and I'd urge you, if you're going to adopt these set of procedures, to apply the same substance to those, or else we're going to be off in litigation land again, like we were last cycle, because there was no procedure in place. So I'm not particularly expecting a response to that. It's just a friendly piece of advice, because I think those challenges are coming. My second substantive comment on this procedure is I do think the board needs to consider what it's going to do if you get challenges that allege a pattern in practice of either voter signature or circulator signature forgery that extends throughout the filing. I understand the law says you have to investigate and you have discretion in how you investigate. But you do not have discretion to refuse to investigate or to ignore evidence. So I think the board needs to think about what's going to happen when you get a pattern in practice attack, challenge to circulator signatures. It includes going beyond the sample. Again, I understand the law. It says you have discretion in how you investigate, but it's an abuse of discretion to ignore evidence or to refuse to investigate at all. Thank you. That's all I have. I'd be glad to take questions.
Yeah, you, you just used the term pattern and practice challenge. Can you elucidate what you mean, what you anticipate that we will be faced with?
I don't anticipate anything. But again, I just know that now, particularly with increasingly sophisticated technology and scanned petitions, which your staff helpfully provides, it's much easier to go through petitions, either looking for patterns of forgery among signers or frankly among circulators, which is our topic today. There are vendors out there with records of past petitions and the signatures on them, either of the signatories or of the circulators. And it's easier and easier now with technology to compare those signatures and say, you know, Mark Brewer signed this as circulator back in 2020, this petition, and he signs this petition now, but the signatures are different. And so I think you're going to get challenges along that line that go beyond the sample. And the question is, what are you going to do with that? Are you going to ignore it or are you going to investigate it? It's coming. I'm just, again, as with my first point here this morning, I'm trying to help the board anticipate challenges that are coming. It's great that you have this procedure. This is for candidates, but it doesn't cover these latter 2 points that I've mentioned here this morning. Thank you.
Good morning. For the deference to the new court reporter, Eric Doster, ERIC, D as in David, OSTER, and welcome. Chair Housecamp, members of the board, Eric Doster on behalf of Good Government. I thought that these circulator challenge procedures before this board today were dead and buried long ago. Why would this board even consider adopting procedures that have as their mission the disenfranchisement of voters who filled out and signed a petition correctly, but because of some challenge signature that a circulator may or may not have signed years ago, that a petition could be disqualified and with it, the disenfranchisement of voters? There is no reason to carve out an exception for circulator signature challenges and require that all other challenges must be resolved prior to 60 days before an election, but that circulator signature challenges can go unresolved indefinitely. And make no mistake, any suggestion that adopting procedures for circulator signature challenges is somehow required by this, by the Court of Appeals in that holiday decision is completely false. The Court of Appeals never stated or even hinted that circulator signature challenge procedures be adopted. In fact, when the Court of Appeals in that case stated that the board has, and I quote, significant discretion, end of quote, with respect to circulator signature challenges, that means that this board has the discretion not to carve out a special exception for circulator signature challenges. So I respectfully request that this board keep these circulator signature challenge procedures dead and buried. And thank you for your consideration of my brief comments this morning.
Questions?
I just have a quick question. What do you mean when you say dead and buried? You started by saying you thought this had
I
been
thought-
dead and buried.
I thought it was. I thought that based on conversations on earlier board meetings that we were just going to move on because your petition manuals articulate other challenges and the best practices in there, both for ballot questions and for candidates. So it's all in there. And yet we've got this special carve out for circulator signature challenges. And it just, there seems to be a disconnect. Why do you have a special carve out for that? Why not have a special carve out for some of these others, which you don't? It's all properly in your manual, which this board unanimously adopted. So that's why I thought they were dead and buried.
This issue's been on the agenda a few times.
I understand that.
Okay.
And I just thought
Well,
from the
I-
last conversation that it was dead and buried, so.
I know you keep saying dead and buried, but that's what I was trying to figure out because it's been on the agenda. So I was confused why you thought it was.
And I was
Okay.
surprised to see it on the agenda for today as well, so.
Instead of dead and buried, do you mean resolved?
Just that it wasn't, it just, the board was just going to move on. And I mean, we have other pressing issues before this board. I mean, tackling circulator fraud and signature fraud, you know, how do we get all access to the QVF signature files? You know, things that came up over the summer with my dear friend Steve Liedl, where we had, yeah, I can say that now because we're co-counsel on a case. Where where he objected to the fact that I was handing out an exhibit for this to ease my presentation to this board, and that was somehow objectionable under whatever that is, Rule 6, which it isn't. I mean, we've got other pressing issues, but
We don't have anything pressing from the issue with Mr. Liedl. There's nothing pressing from that situation. So I'm confused why, first of all, why we're even talking about that. And second, the way that you're characterizing that you thought it was dead and buried doesn't mean that you're right. So I guess that's all I'm
I
saying.
agree. I said I thought. I apologize.
Well, I thought there was something you had heard that it was dead and buried. That's why I was asking you, because that has never been our understanding.
Okay.
Mr. Cordes, do you have any questions?
I don't have any questions.
Mr. Duster, if I'm hearing what you're saying correctly, you think a better approach to having a sheet or two on procedures, expectations, you think it would be better to simply incorporate that in the existing manuals? Is that what I hear you saying?
It's already incorporated in the existing manuals. So you already have challenge procedures and we already have the requirement. Like I see no reason. the way I read the statute, these procedures say that the circulator signature challenges don't have to be resolved 60 days before the election. And I understand that's what the Holiday case said. I don't read the statute that way, and I think it's inviting chaos for this board to certify a candidate for the ballot, and based on everything else, signatures, whatever, dates, form, whatever you all look at, and then to all of a sudden, but we can look at these circulator signature challenges, which we've carved out specially, and that doesn't have to be resolved prior to 60 days before the election. That to me makes no sense. So
Yeah, go ahead.
I don't read this as saying that they don't have to be resolved. This is a way to resolve them in a timely way. That's what we've been trying to achieve. Obviously, the issue arose when we didn't have the opportunity or the ability to resolve them prior to certifying somebody to the ballot, Cornell West. But this raised for us a question, as did the Holiday decision. I disagree with you about your interpretation. Holiday said that we could not refuse to, that the fact that we didn't have a procedure for resolving circulator signature challenges did not mean that we didn't have to address the issue. And so this obviously is an attempt, which we have discussed on a number of occasions, to resolve that issue. And I think it is, it's not a carve out. It is, we are addressing challenges to circulator signatures, which we have an obligation to resolve, and hopefully before the time when we need to address the validity or sufficiency of a petition.
well,
Or of a nominating petition. And I agree with Mr. Brewer that this should similarly be applicable, although this is not what we're addressing today, but it should equally be applicable to ballot questions.
Well, if I may respond, Vice Chair, I'm not saying don't investigate circulator signature challenges. That's not what I'm saying here today. I'm merely pointing out that there's a carve out for the time frame here, and I'm looking right at under the section that says resolution of challenges, and it says, however, circulator signature challenges are not required to commence or be completed before a decision on the sufficiency of the petition signatures. And I don't, I think that invites chaos before this board if you've already looked at all the challenges that have to be filed within, 7 days of the petition deadline, and then you've resolved those to however you've resolved those, and then somehow these are still out there hanging, and that doesn't make any sense, and it just invites chaos.
Is it possible that's a wording in the way that this is put? And let me step back a second. I also, when I read this, I read this, by the way, with the Holiday decision as well. And Mr. Dosser, I guess the way I'm seeing this is that we have a responsibility to canvass the petitions and either approve them or reject them. Correct?
And
Wait a second.
to Vice Chair Gerwitz's point, you have the duty to investigate when a challenge
Well, wait a
is
second.
before you.
But that's where I want you to stop for 1 second. Hold on,
Okay.
one minute though, because I'm trying to do it in my,
Sorry.
I'm
Right.
trying to do it in my non-lawyerly way here. So we have a responsibility to canvass based on how we view, how we hear, how we go forward. And we've done that, right? We approve or we disapprove. When I read the Holiday decision, it's one of the things about that with me is that it very clearly unbraids the possible. If you have a signature that is potentially fraudulent and an investigation is ordered on that signature, that seems to me to be something that has to do with the individual that signed it or the company that caused the individual to sign it. Okay, that seems to be a completely separate lane than us approving or rejecting a petition. I think, and Mr. Fracassi, help me out of this deep well here, but isn't that part of what this is supposed to be about, is saying, we're going to investigate, but that has nothing to do with whether we've approved or rejected a petition. You're not reading it that way?
So it might be helpful if I explain that section,
Please.
maybe that would be. So as I read the Holiday case, the Holiday case specifically said that that the board is not obligated to resolve prior to the certification deadline. But the board is obligated to investigate. And the reason for that is because there are other provisions under the statute that have a remedy other than just affecting a candidate's ballot access.
Correct.
Like the investigation side of things, the banning for future, et cetera, those provisions. So the resolution of the challenge language that we have is intended to, one, reflect that, but two, to say, let's take an example where there is a challenge against one signature, not even one circulator, just literally one single signature, and the candidate they have a cushion of 5,000 signatures. If you're challenging just one circulator signature, in that instance, we're not obligated to investigate that prior to certification, especially in that instance where it's like, let's presume it's invalid and that signature gets invalidated. That doesn't affect the ballot access. It's the same logic like we do with candidates right now, where we say, if you're challenging 10 voter signatures, but your cushion is 50, even if we assume all of those are invalidated, you're still above. We're just going to be finished with that challenge because it doesn't affect the outcome of the ballot access at that point. So we're extending that logic to the same that same concept. I hope that answered your question.
It answers it. I think it answers it. I'm still back on this issue that if we, Mr. Duster, if you come to us with a challenge on a signature gather or on any signature, and the decision of the board is, you know what, there's merit here. There's something to it. We think that there probably is a problem with this signature gatherer's signature. The decision that we make is, regardless of an investigation, the decision that we make when in the past here, when we've reviewed those, we make spot decisions. We decide right now, are we going to accept this story? Are we going to look at this signature? What are we going to do with it? Are we going to approve this petition or this ballot proposal based on what we're seeing right now in front of us? The fact that if we go back to Cornell West, which seems to be at the heart of a lot of this, if we go back to that, the fact that it was pushed out to an investigation, I looked at that as a separate lane. I looked at that as a lane that, okay, we've decided we're going to approve this petition. It's approved. It's a done deal. We're not going to revisit it. The fact that we had signatures that were potentially fraudulent and an investigation was launched, what to me was a separate issue. That was a sidebar issue, and I feel like that was vindicated by what the court said in Holiday. Am I missing the point here?
I guess I don't know what the question is exactly, but
Well, again, I see that what I see happening here is and I would also say this is a manual to guide people in how they approach us and how they process petitions. This is not a statute that we're talking about this morning. This is a guidebook, right?
it's the procedures of this
The
board.
procedures, though, being a guide. And the other part here is that I think there are wording issues here that I'm not happy with, but I want to keep in front of us the fact that when we're approving or disapproving, when we're evaluating a petition, we're going to make that decision within the challenge time, within our meeting time. The fact that if we've got someone that we come back with and we say, hey, this is a fraudulent signature, this is a fraudulent gatherer, and we kick that over for an investigation, at the point that we're doing that, that's a separate conversation. That's a separate issue. I see those as two separate things. And that's where I think I may be looking at it differently.
I could, I think they are two separate things. What the procedure, I think is designed to do is what we wanted, is to give us the ability and to put certain obligations on the candidate um, to allow us to resolve the challenge in a timely way. Right, so that if it affects whether or not a petition is going to be approved or rejected, this is supposed to give us the ability to resolve that challenge. However, the resolution of that challenge, if we decide, for example, that a challenge is meritorious, the fact that we act upon it when we're determining whether a petition is sufficient does not mean that we couldn't, as you say, go along a separate road and say, this is a forgery and we want to investigate it for reasons, because we don't want people to submit forged signatures to us.
No, I agree. I agree exactly what you're saying, but I also, what I'm hearing you say, Mr. Doster, and what I is the same concern I've got here is a challenge comes before us, we make a decision. We decide that we're going to put something on the ballot, let it go forward. But meanwhile, there's been some signature fraud and it's a very close number. And now an investigation has started. We don't want to create something here where 3 weeks down the road, we're now coming back and saying, well, we have to take this off the ballot because of, right?
Right, yeah.
But we also want to have it where we're not saying we can't make a decision on whether to put it on the ballot or not put it on the ballot based on the fact that we have to wait for an investigation.
We have to make a decision,
We have to make a decision within the time that it,
right?
when you come to us with a challenge, or when you come to us to submit a petition, we're going to make a decision to put it on the ballot or not, right?
Let me, the statute that allows this board, and Mr. Fracassi has discussed it, one of the remedies for this separate track
Yes.
is the disqualification of the candidate or the ballot question from the ballot. So I don't know how you can neatly say, well, this is a separate track, because it really isn't. It potentially could be the same track or the same outcome that the challenger wants. So
That exists today.
yeah, I understand that. And there's nothing that prevents the Bureau of Elections, if they see fraud, from referring it to the Attorney General's office for investigation and review. So it's not necessarily a board decision.
Right.
What Vice Chair Gerwitz has correctly pointed out was the holding in the Holiday decision that said you do have a duty to investigate when you have these challenges. And I'm not saying you don't, absolutely not. You do. But I guess my concern is this separate carve-out for this type of activity, whereas other things don't have the separate carve-out or the separate time frame. So
Well,
that's my only point on
the-
that.
part of the issue here is, and again, when I look at this when I look at the first couple pages of this, especially with what's been added in with best practices, right? The idea that, if a candidate is using a petition circulators who are not registered Michigan voters or who reside out of state, the candidate should provide a signature exemplar for each unregistered out-of-state circulator at the time that petitions are submitted. This will allow the Bureau to authenticate the signature if the circulator's signature is challenged. This kind of a guideline goes right to exactly what we experience is not just in Cornell West, but what has been an ongoing issue since I've been on this board, where there have been for-profit companies who are bringing in out-of-state circulators, and they are bussing them around the state of Michigan. You've met them. I've met them. And wait a sec. They're doing this, and we have a group of people who we can't verify their signatures. And to me, that's the crux of where the problem is. If these were signatures in the QVF, Mr. Fracassi and his group could validate, or they could send it back to a township clerk, or they could do whatever they were going to do. We have the sample.
These procedures apply to in-state circulators as well.
I know.
That are on the QVF. So we're not just talking out
Well,
of
they
state.
do, except that historically, the system has worked very well for evaluating people who we can evaluate their signatures against the QVF, right?
Yes.
The elephant in the room here seems to be out-of-state circulators or circulators who are not registered voters in the state of Michigan, who are gathering signatures, and when there is a question about their signature validity, we come up with pumping mud because we have nothing to verify against. As a matter of fact, later in the meeting, we have an item at the end of this that's not on the agenda to chat about. But, that seems to be where most of this comes back to, is signatures that can't be checked. And
They couldn't be checked at the time that we were dealing with the Cornell West petition because we didn't have the procedures. So what we're trying to do, and I think that this does it, is give us the ability to do the investigation and resolve the challenge prior to the time that we make the decision to certify or not to certify the candidate or ballot question. And as you say, and that decision is one that we have to make at a particular time, period. But that doesn't mean that we can't address the issue of forgery. So I don't think, I'm not sure what you mean by carve out, but because I really don't, but I'm not sure that it matters. I think this, we've talked about this repeatedly and we're very concerned, and I know you, Chair Hauskamp, are particularly concerned with the firms that hire circulators, particularly out-of-state circulators, and don't do a responsible job. And I think that this does put a burden on the person, the candidate or the ballot question committee that is using circulator firms. This puts on them the obligation to have the information available that will allow us to resolve challenges to the work that they submit to us, right?
well, I guess that's,
I hear from Mr. Brewer a concern about what we're going to be faced with in the future, and I have heard you express that
I have
concern,
the same concerns.
right?
But I also have concerns that we are, to me, a set of guidelines that says to people who are submitting petitions, you have a responsibility with your circulators, whether they're volunteer or paid. These are people who are functioning almost as quasi notaries, aren't they?
To an extent, I suppose.
But I mean,
Make
but
them
if I
look-
go to a notary, then that individual is going to attest to my signature. That was me. These circulators are being given an enormous responsibility to validate the signatures they're collecting. And it's important that we know that they are who they say they are. And we have
Not
mechanisms.
quite that strict. I mean, yeah, they
Oh,
walk
I
up
know
and they
that.
say, are you a
I'm saying
registered
that,
voter? They say
I'm saying
yes.
that if you
and-
come in here and you've got, and a challenge is made, and somebody says, hey, wait a minute, Jack Smith is the circulator here, but this isn't Jack Smith didn't sign this.
And how do you know that? I mean, if you look at these procedures, somehow exemplars from they're on some petition
No,
from
we're gonna
5 years
talk about that
ago.
one, 'cause that's a big problem.
That doesn't make any sense. I mean, as opposed to the example within the procedure, they're laid out in the procedures about the person that circulated 10 petitions and 2 of the signatures don't match. Somehow that's a lesser quality of proof on signature fraud than something that may or may not be Richard Housecamp's signature from 5 years or 10 years ago. That doesn't make any sense in the
No,
world.
no, I actually have a problem with that in here, which I was going to bring up later anyway. The idea to me is that when we evaluate signatures, our process is to evaluate signatures using the QVF today, right?
Yes.
The section that we are talking about in here that talks about, well, if you're evaluating a circulator signature, somehow you should be able to pull an exemplar from previous petitions that may have been filled out, whether it was last year or 2 years ago or 5 years ago. I have a particular issue with that one. Director Brader, I had an issue with that one when I was first reading it. I actually made notes on that this morning, that it seems to me that if you're going to evaluate the signature, it needs to be evaluated against against an official source. So whether that official source is the driver's license from the state of Illinois, or whether it's the QVF file, it seems like we shouldn't be saying, bring us signatures from some previous petition.
But the challenger doesn't have an official source. The challenge and the challenge,
Who that is, though.
right, but the challenger can say, the question is what rises to a meritorious challenge. So the challenger can say, this is the circulator signature. These are the circulator. There are 3 petitions that have this circulator signature. They're all in different handwriting. That's pretty problematic. And we would say, you're right, that's problematic. Let us see, a handwriting exemplar, an official source. But if what the circulator has is, this is a signature, I'm sorry, what the challenger has is, this was a signature from this person this time, and this is a signature that was from this person a couple of years ago. That's the most they can get, but it's, I think, enough to raise.
I disagree with you. I think I don't see that as legitimate. I think if you're going to compare a signature, go back to an official document.
don't
and
have
compare it. It doesn't matter. I mean, the challenger can call it whatever they want, but when we go in and we look at that, if Director Brader's team goes in and evaluates a signature, they should be using something like a QV,
They are.
right?
The question is, why are they investigating? They're investigating because of the challenge. And if the challenger doesn't have an official source, but what you're saying, and I agree with you, is that when the challenge appears to be meritorious, the Bureau needs to look at an official source. That official source may be a driver's license or a W-4 form. I think the W-4 form is probably the best. If they're paid circulators, the circulator, the
But this document, to me, again, the way I read it is it's advising people that that we may consider petition signatures, or I'm sorry, circulator signatures from previous petitions. Mr. Fracasey I guess, Director Brader, are you going to respond to that one?
Sure, I'll try. Adam can help me if needed, but I mean,
Go ahead, all right?
I agree with Chair Gerwitz's take on that. I mean, what this section was talking about, signatures from the circulator and other petitions. What we're saying is, if you're going to challenge a circulator signature, you have to give us some kind of evidence. Why are you saying this isn't their valid signature? This is the kind of evidence that a challenger could find and provide to us. But that's not the evidence that we are going to seek to validate the signature, which is why earlier in the manual, we're talking about, we want the petition sponsor to provide us with exemplar signatures that come from official sources. And that's what we would base the review on, just like we base it now on qualified voter file whenever we can. Now, if the petition sponsor doesn't provide that exemplar to us, then we would just have to do the best we could based on the information we had available. But it wouldn't be the case that we would somebody would challenge, say, this doesn't match the signature from the circulator in this other drive from a few years ago. We're not just going to take that and say, oh yeah, those don't match. We recommend this be disqualified. We're going to say, okay, I see why you're challenging this. Now we're going to go back to the sponsor and ask them, if they haven't already, to give us an official signature so that we can actually make a recommendation to you as to whether it actually is a circulator signature.
I understand that. No, and I appreciate the clarification. My concern is that if I were somebody who was processing a petition or looking at a petition or thinking of challenging a petition, the way that it's worded in here, I think is ambiguous. I don't know. That's, like I said,
Yeah.
Mr. Cordes, have you?
Yeah, I got a couple things. We're dealing with, we've done one investigation. And I do agree, this almost seems like when it says, oh, you can go back and find a signature from, a past petition, that we're almost inviting to, all kinds of potential challenges. Um, uh, because they can go find, one old signature that someone scratched quickly in the cold of January and say, oh, yep, no, this is no good, this is no good, this is no good. So I'm in agreement. I understand they don't have access to the QVF. Totally get that. I think it's super problematic that we don't have, that we hold people accountable, especially, this is getting a little off track, but this kind of goes back to the 2022 issue where, we expect candidates to, ensure the validity of their signatures, but they have no official means for doing it. That in itself is a challenge. I guess my big question is, we've done one investigation into this where basically we got to the end of it and it was, we don't really have any options when we were done in terms of holding people accountable. My question is if we pass these procedures, are we limiting ourselves? We don't know what we're going to be facing. Like, are we actually limiting our ability to handle this because we're putting this in writing after just one? I know we're taking our best guess. I think a lot of the stuff in here is good procedure, but are we actually limiting how we can investigate a problem by putting this in writing, only having done one of these investigations in the past? I know that's kind of ambiguous, but like, are we limiting what we can do? Because, it says we have to do this, but, when we're actually dealing with one of these issues, we feel like there's a better way of handling it. Are we limiting ourselves in these procedures at all?
I don't see that it's a limitation. But, I would like to hear Director Brader on that.
Well, so I don't think it limits in any way the ability to ultimately investigate these and refer them to prosecution if there's fraud. I think what this does is understanding that people are going to challenge petitions this next year. They're going to come in and they're going to challenge them on the basis they're going to say that petition is not signed by the circulator because that's not the circulator signature. What we're trying to do is create some predictability for staff and I mean, for the sponsors, for the challengers, for BOE staff, and for the board as to when we get those challenges, this is the process we're going to follow to evaluate the challenge and make a recommendation to you, and that you will use to make those determinations. So, I mean, I suppose any procedure is somewhat limiting in the sense that you're laying out the way you're going to handle something, but that's just, I mean, I think we need parameters, or else it's going to be chaotic and unpredictable as we go into next year. But in terms of, ultimately, if people are, potentially committing crimes, I don't think it limits our ability in any way to investigate that.
Fair.
One of the things that I think bears consideration is that in the case of Cornell West, we had an out-of-state candidate using out-of-state circulators, and we were very pressed for time. And we didn't at that time have any procedure, which is what we said to the court. We didn't have a procedure for investigating those, and so we couldn't. But now we have a procedure. We're trying to come up with a procedure which allows us to resolve those challenges in a timely fashion. And if we resolve them by saying, we can resolve it in two ways. I mean, we can say, yes, these appear to be forged signatures, but they're not sufficient. There are not, there's still a sufficient number of valid signatures that we can put the matter on the ballot or the candidate on the ballot, but we'll still investigate because people are submitting bad stuff. And this seems to me to really address what we need to address, what the court told us. The court told us, don't tell us you don't have a procedure. So we got to come up with a procedure, right? I mean, that was pretty clear. So I think that this is a response to the holiday decision. And it recognizes what Holiday also recognized. Maybe there are some things you can't do in the time frame which is available to you, but do the best you can. And we don't anticipate, at least in this election cycle that's coming up, we're going to have maybe ballot questions, and we're definitely going to have a lot of candidates, but they're going to be in-state candidates who are going to want to make sure, that their candidates get on the ballot, and they're going to be giving us the timely information that we need to determine whether they should be on the ballot. Right? I mean, it's just telling them, be ready. Be ready, and be ready so that we can do the job that we need to do if there's a challenge to your circulator signatures. And this all came up because we recognized in the Cornell West case that where we had decided to do random sampling for candidate petitions, that did not, the one thing that we were not able to do with that random sampling was validate the circulator signatures, right?
Yeah, I mean, we didn't have a process to handle challenges to the circulator signatures within the sample. So that's where we just sort of brought it to the board because we didn't have a process to evaluate them.
So I think that this is, it's a step in the right direction. And if we need to take other steps later, we'll take them.
So if a challenge was made and the basis of the signature called fraudulent because the challenger had gone back and looked at petitions from 2 years ago, Mr. Doster, the case we were talking about a minute ago. And that's what's presented here, right? And granted, that may not be what the Bureau is going to use to evaluate. But I still see the same issue that we faced with Cornell West. The Bureau decides to investigate. We have a challenge. We don't have an exemplar signature. That's a legitimate, we don't have an example at all. We don't have an example from another state. We don't have an example of a current signature. That, we keep circling around that, but that's what started all of this. And that, by the way, is what's gone back in time, even before I was on the board. This is not new. If you come to me, Mr. Brewer, with a bunch of signatures and you say, these are all fraudulent, Mr. Fracassi will cancel his weekend plans and go into a room and check every one of those signatures against the QVF, happily. That was on page 7 here. But the issue here, that process works. And to have a guideline for that, whether it's in the main manual, whether it's in a call out sheet, doesn't change anything. The problem we keep coming back to here is Jim and Sue came from North Carolina and they're staying at the Red Roof Inn in Dearborn gathering signatures. Now, we have no idea who they are. And we're not ever going to know who they are. And that seems to be the problem that we have to solve on this board. And what we've talked about before is we haven't been able to solve that problem because we have to go back to the legislature, right? We don't have a way to demand or require this.
The best practice isn't the law, right?
Practice isn't the law.
We
but
tell
this
people they've got to
is a little
submit an
bit of a best
exemplar,
practice
yeah.
here. If the best practice here says, hey, if we don't have if you're a candidate or a circulator company and you can't provide us with an exemplar that's a legitimate exemplar, well, we're simply going to default and assume that we're going to throw it out. Is that what we're saying?
No, and that would be up to the board. I mean, what we're trying to do is narrow down. So I acknowledge there will always be some instances that our procedure doesn't allow us to have a really, straightforward resolution of, and we have excellent and creative legal counsel on all ends of the political spectrum who always bring those to you. What we're trying to do is narrow down the instances in which that happens. So if a petition sponsor or a candidate or petition, I guess a campaign reads this manual, hopefully what they will do is they'll say, okay, we're going to make sure we have a good signature for all of our circulators, so that if someone then comes in and challenges it on the basis of whatever their evidence is, we'll then be able to go back to that campaign and they'll be able to give us that signature and we will look at it, and assuming that the signature in the circulator box in the petition matches that official source, we'll look at that challenge and say, no, these are good circulator signatures, and then we'll recommend that to you. And ultimately it's always up to the board, but the board would likely agree with us on that. There will, if the campaign cannot do that, if for whatever reason they can't give us an official signature or any kind of exemplar signature for the circulator, and all we have is the signature that's on the petition, and then whatever evidence that the challengers have brought to us in support of their challenge. In those cases, we would just evaluate what we have before us, and we would make a recommendation to the board based on what we have. I can't tell you what it would be necessarily because it would be case specific, but there probably would be instances and we would just say, we cannot make a recommendation on this, and the board would have to decide what to do with that. But that's not any worse than where we are now. What we would be able to do, however, is narrow down those instances. So we are hopefully minimizing, number one, those really tough cases for the board. And number two, hopefully minimizing the situations where that actually determines whether or not the petition has a sufficient number of valid signatures. Because if we can narrow down the universe of these really tough ones, it's going to be less likely that whatever decision the board makes is going to actually determine whether that candidate gets on the ballot or not. Now, we can then go after the fact and investigate it regardless of whether it affects whether they make the ballot, to see if there was any criminal behavior. And that's where the investigation doesn't need to be done before the certification deadline. But for purposes of helping you make the right decision on each of these campaigns, candidates, before the petition deadline, that's where we want to have as much predictability and clarity and minimize the really problematic cases as we can. And that's what the attempt is in this process.
I think, Chair Housekamp, that addresses one concern that you have expressed repeatedly about signature gathering firms. This says, okay, if you have hired Jim and Sue from North Carolina to gather signatures in Michigan, you better be prepared to establish to the Bureau of Elections and ultimately to the Board of Canvassers that Jim and Sue are actually signing with their names and their signature. It's not, I agree with you, it's not, I agree with Mr. Doster that it is not verification about the validity of the signature, but the circulator is saying that this person I asked this person if he's a registered voter and he said yes, blah, blah, blah. But this is putting more responsibility on the entity who hires Jim and Sue. And that's what we want, right? Because I understand that in 2022, and it was just before you got on the board.
Yes,
it was so interesting. I see Jeanette back there. And Paul wasn't here either. And this didn't even arise then, the question of, because the signatures were so clearly forged. It was really evident, and the Bureau did a great job of going through and establishing to the Bureau's satisfaction. Actually, it wasn't complete. I think there was some disagreement about that on the board, but establishing the fraud. And there was concern on the part of legitimate that the candidates, they thought they were doing the right thing. They thought they had the signatures to get on the ballot, and they were essentially defrauded. Well, this is a way to say, make sure that whoever you hire to get you on the ballot does a good job. and doesn't submit stuff that is so either evidently without challenge or after investigation of challenges that those signatures turn out to be invalid. So it is putting the necessary obligation both on the candidates and the ballot question committees and on the circulator firms. And it would be nice, I think, I'm not sure, because I know it might be that legislation addressing circulator firms is something for the legislature to consider, but this is where we are. in
Where
the
we are
meantime.
today, I
In
get
the meantime.
I would just follow up. I think what Mr. Brader said makes me feel a little bit better, which is this is a case by case basis sort of thing. Because my biggest concern from the very beginning, I've said it every time we've opened this up, is when we're dealing with circulators, we're also disqualifying potentially voters who believe they were signing in good faith for either a candidate or something that they believed in. And I think that has equal, if not more, value in protecting those people's rights as signers. And from my perspective, you know, and I suppose this will end up being up to us, but I'll go on the record today. I don't believe that using an old signature from again, something that may have been signed on, if we have two contradicting signatures based on unofficial sources, I don't believe that is reason enough to disqualify the signatures of those voters who signed thinking they were putting a candidate on the ballot. And I know that we've talked about basically saying, all right, unless we've got solid proof, we need to protect those signatures. I've heard Mr. Frakazi say that. I think that is something that we very much need to consider, that if like you said, sometimes it's very obvious, right? If it's not obvious, but even when we're looking at some of the Cornell West signatures, I think you had some disagreements, even with Mr. Frakazi, on what signatures were potentially invalid or not. So I would just say, I think it is extremely important that we keep in mind that if the signatures on that form are valid, we better be darn sure that the circulator signature is in fact invalid. I don't necessarily believe that old signatures from past petitions are reason enough to do that. But I understand that will be taken on a case by case basis.
No, it is certainly true that there could be valid signatures and an invalid circulator signature. But that's what the statute says.
Understood.
Yeah, yeah. So that's what you're faced with. And that's why the candidate or the ballot question committee has to be careful about the circulators they use.
Yeah.
They don't want the circulators to be messing up with the voter signature.
I agree. My point again is just that we better be, I think the bar for disqualification should be very high and should include some form of official signature.
Which it does, right.
Well, again, if,
So we've got these two things. What gives you reason to investigate?
Understood.
And once you've investigated, what gives you the reason to make it, what gives you the information you need to make a decision?
well, even finding signatures from a gatherer from a couple of other petitions doesn't mean that those were legitimate signatures either. It simply means that they were unchallenged and uninvestigated.
Right, but that's why you have to have some official thing
Right.
to allow you to investigate.
Yeah.
That's at the end.
Right,
It's
know what?
the point.
Yeah.
And
But even at the end of the day, and I don't want to belabor this, even at the end of the day, we're talking about what we have in here is this is best practice. It does not mean that they have to give us that, right? So at some point, I don't think we got a handwriting example from every single one of the Cornell West signatures. So in that case, and it's going to be up to us, right? In that case is, if we don't get it, we definitely want it. Obviously, that would be the most helpful thing. But if we don't get it, I think that should be a very high bar for disqualification.
Yep. We have another public comment. Ms. Bradshaw, I guess my question would be, what took you so long? Do I have to tell you to push the red button? There you go.
So good morning. Do you need me to spell my name correctly? Um, Going through, so I sat on this board, Paul, if you don't know, I sat on this board from 2013 till this year. And so reading through that procedure was kind of like a breath of fresh air, because sitting where all of you sit and having been there to reevaluate circulators, and also being the individual that kept on saying it is a legal document, please do not put your name on it until you read it and or use your real signature. Having a procedure in place for all of you to start with is going to be vital. Because having sat in your positions, not having procedure, it kind of was the Wild West. And at times, and my admiration to my legal friends that are sitting behind me, but ultimately, Member Cordes, you are correct. It's an individual signature because they wanted that person on the ballot. And if that person has been disqualified, now you have taken that person's voice away. But I feel it's very important for that procedure to be approved. Now, I can understand if you have some hesitation, but it was even more so when we did not have things in place publicly. And so for a candidate seeking office, here is a guideline for you. Because not every candidate has the money, or even sometimes they want to make a difference. It gives them something to look at, and it gives the public to understand what your procedures are, so that this board is not a mystery. When we're talking about nominating, and I do absolutely support what Mr. Brewer said about ballot questions, referendums, initiations, constitutional questions. I know everyone usually lumps it into a ballot question, but let's talk about what they really are, which is initiation of legislation, a referendum, and a constitutional amendment. Because each of them has a different procedure. And so whatever we can do in the public eye to clarify and to demystify, I think is in the best interest of every citizen in the state of Michigan.
Thank you. Any questions?
Nice to see you, Jeanette. And thank you for that.
A lot of good discussion about this. The idea of having a procedure and guidelines, I think that signature gathering is important enough that putting people who are going to gather signatures, who are going to submit petitions, putting them on notice that this is extremely serious and here's what we're going to look for, I think has a lot of merit. I think that might, in the absence of legislation, that might help us through the weeds. Okay, so that's the good news. The other side of this, though, is I have an issue with, I'm concerned that the board's hands would be tied with this a bit. And let me go down that road for just a second. We've already discussed here that there's really only been one situation where we've done an investigation. Is that, everybody's on board with that? We did that with Cornell West, right? When it comes to signature gatherers, we don't have years of experience investigating potentially fraudulent signature gatherers that we can't find signatures on.
I don't think that's true.
Well, we've certainly had challenges that involve
There have
circulators.
been challenges in the past, but those have been challenges predominantly resolved by having signatures in the QVF file, right? Not.
There were circulators As I recall, there were circulators who we referred for investigation in the 2022.
Yeah, a whole bunch, and then some also in 2024, but those were referred on the basis that it looked as if the signatures were forged by those people, not necessarily that their circulator signature was a forgery. So, I mean, I certainly agree that the West, petitions was the most comprehensive investigation and review that we have done in terms of the validity of the circulator signature. We do get challenges though, every election cycle that involve issues with circulator conduct or the way the circulators have completed the circulator block.
Thank you. The- Yeah, I see this as two separate arguments. I see the argument that, yes, we need to put out to petition processing people, petition generators, that this is a really serious issue. I also think Mr. Cordes has raised a very vital issue that we've raised here before, and that is if you eliminate an individual signature because it's been suspected of being fraud, an individual signing, an elector signing a petition, that's a one-to-one. When you eliminate a petition with people's signatures on it, with 2 voters or 10 voters or 5 electors, because of the suspected actions of the circulator, that elevates this considerably. I agree that we need a sheet that says to petition circulators, we're going to hold you to this standard. This is important. My problem with this document is I'm not 100% on board with how it's roping us in here in terms of what our actions are limited to, or
I don't see the limit. What are we limiting ourselves to? I'm confused about this. No, there's nothing in here that says that if we compare a signature to an old one, that then it gets eliminated. Then that brings it into a deeper investigation. So I don't see I'm not getting the concern. Maybe I'm not understanding.
one of the concerns I guess I have with it, and just the way I'm, this whole, again, go back to West, but the whole way this comes about is I'm concerned that I'm concerned that that we don't know all we need to know yet about how the signature gathering is functioning, particularly with out-of-state signatures, with out-of-state circulator.
I mean, this isn't new. It's new for us as far as, like when Paul said Cornell West is the only one we've investigated. This has been going on for years, we're new on the board. I don't think this is a whole, and maybe we should talk to Brewer or someone who's been here longer. There have been many situations before. And there was no policy up front for people to be able to look to for both people who are getting involved in collecting signatures and also the board. And I don't think this is, are you saying this is going to what Mr. Doster said, disenfranchise voters? Is that a concern of yours?
Yeah, absolutely.
How though? That's what I want to delve into because I'm struggling with that. And I don't want to hear from Mr. Doster again on it. Oh, I thought you were. That thing. Sorry, you can go.
And
Apologies.
just from a clarification perspective, I don't disagree. I think, especially when it comes to campaigns, I don't disagree that the board putting out as much information to help guide them as possible, right? Your average campaign is not a bunch of professionals who have, great offices, HR, all that stuff, right? So us giving them as much information as possible to help make sure that they have good signatures, are properly making the ballot, following the rules. I think putting out a document that has that stuff is good. As I read through this, Mr. Prater, if I'm wrong, let me know. I mean, really, this is what you guys would do anyway, right?
Exactly.
And, and, and the only thing I see here that may be like a little bit different here is you are like, put this requesting of the exemplar, right, is probably a fairly new, like, that's a newer thing, right? And so us just giving you guys the go ahead to say, yes, make sure that, yes, that's what we're gonna do. You're gonna request the exemplar. Great. Just put that exemplar out. And then really you guys will make your recommendation, which you would do anyway. And then it just comes to, at the end of the day, it still comes down to us being able to evaluate what your opinion is, correct? Am I wrong in anything that I
think
just
that's
said?
exactly right.
Okay.
I am sensitive, Paul, to what you're saying about the voter who signed, who legitimately signed.
Okay.
In 2024, the congressional district that I'm in is not canvassed by this board. It's all in Wayne County. And I signed a petition for a candidate who I supported. I wanted to see him get on the ballot. And a reporter called me and said, your signature is here. Did you really sign? And I said, yes, I really did. But the candidate submitted other signatures that were fraudulent. And so my desire that he should be on the ballot was, it didn't work. I didn't get him on the ballot. And that's on the candidate. The candidate disappointed me, right? Because he didn't do a good job. And I think that's important. It's on the candidate and it's on the ballot question committee.
Sure. And I guess, again, my perspective, I got two thoughts on that, which is one, I think it's just really hard to hold, I shouldn't say that. I think we should hold candidates responsible for the stuff they can control. They're not having access to the QVF to check signatures, even if they wanted to, I think is generally problematic. The second thing that I would say here is, I think that my conversations are just to us as a board, that the threshold for booting a signature or a whole page of signatures of good voter signatures, the threshold to do that when it comes to whether or not a circulator signature is fraudulent or not should just be very high. That would be my point.
I agree.
Oh, I-
Threshold is one that we're enforcing.
Yeah.
Right? So you have two thresholds, one to investigate and one to resolve.
Right.
So that it's us with our magnifying glasses, which I have done in the past. Yeah, to determine it's the threshold that we're enforcing.
Fair enough.
Enforce the threshold. Yeah.
Yes.
Yeah. Okay.
All good conversation. Vice Chair, you mentioned holding the candidates responsible and statutory they are. One of the conversations we've had over and over again, which is where all of this is generating from, goes back to this isn't about candidates who have a volunteer organization who are gathering signatures. What we have seen come before this board is a candidate hires a company. And there's some expectation when they hire that company that there's a professional standard. And the ones that have fallen through the cracks here, including Cornell West campaign, are the ones where a company's been hired that doesn't necessarily have a standard. And that's what I think this board has, we've had this conversation several times. That's where I keep coming back to the fact, are we setting things up that there's information that we have in this procedure for circulators that's important to a candidate, that's important to a campaign, that's important to a ballot committee. Problems we're running into seem to be with companies that are being hired that are less than professional. I go back to your responsibility with a candidate. How do you know? How does a candidate know? Right?
Could have done a better job. The candidates, that ballot question committees and candidates have the ability, they don't have the QVF, but they can look carefully at their petitions. And they do, some of them do. And all of them should in the future do so, given what has happened in the past, given what happened particularly in 2022, but again in 2024, when candidates didn't make the ballot. They now know that just hiring a firm is not sufficient. You better figure out that that firm is doing a professional job, as you're suggesting. And one of these things, one of the things that the procedure does is give the candidate or the ballot question committee, assuming this is equally applicable, this says you better have signatures from the circulators who are being used to circulate the petitions. You better have those signatures ready to provide if there's a challenge. It just, I mean, it seems kind of basic. It's not something that I think that has been suggested before, but it is something that is giving them at least one of the tools that they should use to make sure that their circulators are doing a good job. You know, quite apart from, I mean, we're not making recommendations about training. We do have something about, you know, telling about, you know, reading the manual, blah, blah. I don't want to suggest that the manual is a blah, blah, because I do think that we suggest to the candidates in the ballot question. I mean, we have really very detailed manuals, which are there for the use of the public and for somebody who wants to get on a ballot. And we suggest that they read them carefully. And that I think the manuals also suggest that the candidates carefully review their signatures to, and a careful review of the signatures on some of the petitions that we have seen would not have just suggested, but would have led somebody who was submitting those signatures to say, whoa, these do not look good. So, I mean, it's just giving tools.
Right.
And
I don't
you
think-
know, I really appreciate Chair Housecamp that you want these ballot you want these circulator companies.
I want to get to the heart of why we keep
Right.
going through this. Okay, it just
Right,
seems like,
but-
it seems like we create procedures, we create guidelines, we have enormous amounts of discussion. But we're not really addressing the problem. Don't misunderstand, the
We're doing as much
guidelines,
as we can without legislation.
Yeah,
Right?
yes,
Okay.
okay.
that's right.
You are correct, without legislation. That comes up later in the meeting. So what do we do with this? Are there areas, we've got 6 pages of a document here. Are there areas that anyone, and we've already had one question, I think, that's been raised, and Mr. Brewer, you raised that question. Does this document apply to other than candidates? Does it really apply to ballot proposals, constitutional ballots and things like that?
Yeah, so the three, Former Member Bradshaw very helpfully elucidated that there's 3 distinct types of petitions. So you got the referendums, initiated legislation, and constitutional amendments. I'll just say we wrote this with the idea of candidate petitions in mind. And that is because of the fact that I think someone please correct me if this is wrong, but Section 552 talks specifically about candidate petitions, nominating petitions, et cetera. And that's what the court was looking at in making its determination in the holiday decision. There isn't the same specific 552, as I understand, doesn't specifically apply to what the board is to do with respect to the other types of petitions. So, you know, but those petitions do need to also be signed by a circulator. So I think it would be up to the board ultimately although I certainly defer Adam or AG's office if you want to add anything. But I think it would be up to the board whether this would apply to the other types of petitions in addition to the candidate petitions.
Is there anything in any of these sections here that need discussion?
I only have one particular thing, and it's mostly just a clarification thing. When we're talking about required supporting evidence, and it says an example of a challenge to a circulator signature supported, I don't need to read the whole thing, but you give some pretty objective language there, such as distinctive flourishes or other matching features. And this kind of comes back to what something Chair Housecamp brought up. The mismatched circulator signatures from different petition drives are compelling evidence that at least one of the signatures is invalid. When you guys are evaluating a potential, the potential evidence, do you have like, I guess, is it case by case, or is this one of those things where if there are, you're looking at only two signatures and they don't really match, is that enough? Or if there's like three, like that I understand a very objective, when you're looking at distinctive flourishes and other matching features. Mismatched circular signatures from different petition drives is a little bit more subjective in my opinion. Do you guys have an internal standard when you're reviewing that? And I guess my thing is are we inviting crazy numbers of challenges based on, two mismatched, potentially mismatched signatures that maybe aren't super mismatched? Like, what do you guys use internally?
So we would use, and Adam can add to this, probably should, but I mean, we would use the same standard for evaluating whether signatures match. I think regardless of whether we're talking about two signatures within a petition or comparing a signature from a petition to the exemplar signature, whether that exemplar signature is in qualified voter file or a driver's license that's provided to us or whatever the other exemplar is. I think, and it is, the standard that we use does, I think, reflect the policy of the statutory requirement and also the policy of not throwing out signatures unless we're sure they don't match, so, but in that example, like, let's say that there's a circulator and they've submitted 10 pages of petitions and the same circulator name, and 8 of those are in one handwriting and 2 of them are in, arguably a different handwriting. I think the first thing that, and then we get a challenge based on that. I think the first thing that we would do is determine, do the signatures on the 2 match the signatures on the 8? I mean, they're somewhat different, but do we think it's the same signature, the same person or not? I mean, and we would apply the same standard we apply to any other signature matching we do in the petition process to make that determination. If we determine that they all match, then, we would we'd be done with it at that point. But if we determine they did not match, I think the next step would be, okay, let's compare these to the exemplar signature, right? And so then you have another set of considerations, like perhaps what would happen is that the 8 pages would match the exemplar signature and the other 2 pages wouldn't. So in that case, our recommendation would be these 8 pages are good.
Yeah.
These 2 are not good. And then the board would ultimately decide that. Or it could be the inverse. It could be the 2 are good and the 8 are not. And then we'd recommend that. Or maybe none of them would match. And we would recommend none of them count. But in any case, I think we would be using the same standard in making those comparisons.
Yeah.
Do you want to add anything, Adam, or is that clear?
No, I mean, unless there's follow-ups, yeah, I think that pretty much clarifies.
Maybe one quick follow-up, which would be, has this standard for challenging any sort of signatures, is this something that you guys have seen before, whether it be for voter signatures or for circulator challenges? Like, is this something you guys have seen? Is that a reasonable?
Yeah, so I would say as far as the standard, it's the same, we would apply the same standards for both voters and circulators. So in general, when we are evaluating signatures on behalf of the board, what we are looking at with a voter signature or a circulator, whatever it is we're looking for any redeemable quality, basically.
Yeah, I think
We see it all the time, like you probably know, we see it all the time, like that's part of just our every responsibility when we're looking at petitions. And it would be the same that we'd be applying on the circulators.
I guess I'm referring directly, I'm sorry if I wasn't clear, to a challenge. If someone was, let's say, challenging actual signatures on if someone were to bring forward a challenge that said, hey, look, these signatures don't match from a past petition drive, is that something that you guys have seen?
Yeah, I think we have seen that more recently, at least in the voter context, where that has come in. We go to QBF. It's again kind of the same similar here. It's enough to maybe investigate, but we're looking to that source. So if it's, Adam Fracassi signed this petition and this other petition over here 5 years ago, maybe my signature changed in between 2020 and 2025. We're going to go to QBF to determine the match because that's what the law mandates. So we're going to look at QBF and we're going to see, does the signature in front of us in 2025 match the signature that's contained in the qualified voter file? Yes or no? And if they're not even in qualified voter file, well, then, then it's invalid for a different reason because you're not registered. So that would, I would say, be the same standard here. Like it may be enough to get us to ask the question.
Yeah.
But then that is like Director Brader explained, it's the next question is up to the board.
I would say my only thought on that again is just, if we're laying out past signatures from different petition drives as compelling evidence, that may be inviting an awful lot of very subjective challenges. And I understand you guys are going to do your due diligence with all of those challenges. I'm not questioning whether or not you guys will do the right thing. I just worry about the number of challenges we're going to end up getting because, people will be scouring past petition signatures. So I would just raise that as a potential concern.
I think we can definitely make clear that, especially based on discussion that, when we're talking to challengers and telling them, hey, if you're going to challenge something, tell us why you're challenging it. Give us what you're basing that on. That is different from the standard that we apply to evaluate the challenge and evaluate the validity of signature. I think we can, to the extent that it seems like those two levels of reliability or how strong the evidence is seem like they're overlapping. We can be more clear about that they're distinct.
Understood.
In the required supporting evidence, we're using the example that, one way to compare these is to go back and pull other petitions that circulator has signed. You've got 10 sheets and, right? We compare 2 of them, or we compare 8 of them, we compare whichever ones we compare. That we're also saying in here that the only challenges we're going to look at are based upon the sample. Are we creating something here where, let's say a circulator has signed 15 sheets, 2 of which are in the sample, and you pull the universe of 15 sheets to evaluate the signature, and the 2 that are in the sample turn out to look okay, but there's 7 of the other ones that look like, wow, they're suspect. Are we opening up Pandora's box when we're saying 2 different things here? We're saying we're going to compare signatures from circulators throughout the universe of petitions. And we're also saying you can only challenge what's in the sample. Do you see a conflict in that?
Is that what sampling is about?
Well, it is until we open up the door and we say, here's a piece of paper that clearly doesn't match.
Well, so I certainly think it will invite a lot of testimony at the whatever the meeting is where this occurs. I view that the same as the issue we encountered like in 2024, where we had sampling for candidates and there were challenges to the voter signer signatory signatures that were outside of the sample. And so, we got challenges that came in that said, this candidate, you need to I understand that you sampled these 500 signatures, but you need to look at these other signatures outside the sample because they don't match, and so there's some evidence of misconduct or fraud here. What we said is, we will investigate those for purposes of possible criminal referral, but for purposes of determining whether this person has enough valid signatures to make the ballot, all we care about for that determination is what's in the sample. And so if you have, examples of fraudulent signatures that are in the sample, then of course we'll review those, and if they're not good, we will throw them out, and that will affect how many are in the sample that are valid, which ultimately determines whether the candidate gets on the ballot. The ones that are outside the sample, for purposes of sufficiency of valid signatures of the petition, they don't matter because we're already accounting for that by sampling. So we will look at those, but not for purposes of determining the validity. I would say that for the circular signatures, it's the exact same thing. Like if you have invalid circulator signatures that are in the sample, then those sheets would be thrown out. But if they're outside the sample, it doesn't affect the prediction of whether they have enough valid signatures. That's based on the number of valid signatures and sheets in the sample. And so therefore we would review those and investigate them for possible criminal referral, but it wouldn't affect the recommendation based on the sample if the challenged circulator signature is outside of the sample.
Okay, thank you. Any? We should get there, yes. Any other final comments from the board on this? In that case, does somebody want to offer a motion?
I move that the Board of State Canvassers approve the procedure for investigating challenges regarding circulator signatures. Further, I move that the board direct staff to use the methodology and standards described in the procedure for circulator signature challenges document when processing challenges to circulator signatures effective for petitions submitted after today. Furthermore, I move that the board authorize staff to make non-subjective clarifications to this procedure without additional board approval.
Been moved and supported. All in favor?
Aye.
All right. All opposed? I'm still going to oppose it. Looks like the ayes have it, though. Is that what I'm hearing?
I think that's what you're supposed to say. You're the chair.
I just said it, yes. And again, I'd like to qualify, my opposition is not because I don't think we need the document. I think we have to figure out how to address the real problem. So it's been moved, it's been passed. Moving on the agenda. Is there any other business here that wants to present to the board? Any new business? No? I actually have one. So during this month of November, I had the opportunity to go to my pet project here, which is out-of-state signature gatherers for profit. And I had the ability to meet with from the legislature in the House and talk about the idea of how do we, is there a way legislatively, are we at a point where we can start to address this? Here's the conversation that was had. I asked them if we could look at it, and Mr. Brewer, you're already going to go to the First Amendment piece. I know you will, because I could, but let me go down the road here. So the issue is out-of-state companies or in-state companies who are hiring for-profit signature gatherers. We have no restriction at all. We have no requirement for those companies to even register with the state of Michigan. We have no requirement. They can come in and they can operate with impunity. And so the conversation went, what would happen if there was legislation that said, you're welcome to come to Michigan, you're welcome to be in Michigan, you're welcome to hire teams of signature gatherers. But if you're going to hire people to go out and gather signatures, you have to register your company with the state of Michigan to do business. And B, you need to register within your organization, verify who the people are that are going out and being paid to gather signatures. By the way, that's the same kind of requirement that I have as an employer if I hire somebody. If I hire a programmer or I hire a salesperson, I have to legally gather information federally and statewide as to who they are and verify who they are. So that conversation was had. The response from the folks in the legislature was, yeah, we'd love to help out with this. And what they've come back and they've said, we can draft some legislation that would require companies to register with the state of Michigan if you're going to employ signature gatherers. And furthermore, it would require those companies to maintain a profile of their employees who are gathering signatures. And so what's the next step with that? That would be getting the legislature on board. The folks I've talked to are in the House. It would require something as well in the Senate. I am neither a legislator nor a legislative staff member. I'm really good at initiating conversations though. So the conversation's been had. There's a green light in the House that says, yeah, you know what, maybe this is something we need to look at. And Mr. Fracassi, you went with me in that meeting. And so I guess what I would ask you to weigh in on you said there may be some next steps that we as a board have to consider.
Yeah, I think so. How we did it in 2023, as the board recalls, we went through quite a significant amount of work to get a legislative package in beginning in 2023, and even the efforts that were done by the board prior to that legislative package being drafted as well. How we handled it then was the first step that we did in looking back was the Bureau actually drafted, like just gave kind of a mock-up of, hey, here's what we would do, just a plain track changes version. And then that was transmitted to the legislature. After the board voted to transmit it to the legislature, supported the draft, voted to transmit it, and then voted to have the Department of State kind of act in that policy-making side of things. So I'm not a lobbyist. I can't lobby for you. I'm in conversations like this purely as a subject matter expert to say, here's how the law is and that procedure, and that's it. I can't advocate for specific policy one way or the other. So if this is something the board wants to explore, I think it would be something similar where we would have to, the board would have to vote to request that the Bureau transmit ideas basically like at a high level, and then request that the department, request the Department of State's support in that like lobbying side of things. I think at this point, it really is just like a high level, like there's no specific language, there's no I don't have like a finalized draft or anything like that. It's just, is this a concept that the board is willing to, or I shouldn't say willing to, but interested in exploring options and trying to get to that point of a draft. From there in 23, when we had a finalized draft, the board actually, all 4 members of the board went to the House and testified as the chair and vice chair member. Ms. Bradshaw remembers as well. We also then, when it came up in the Senate, also had the board testify again in the Senate. I believe that Tony Daunt, then member Daunt, was not able to attend at the Senate. I think he might have been listening on Zoom, if I remember correctly. And then during that, the board, we had conversations in the public of, do you like this draft? Do you have changes? Like, how do you feel about this? And then kind of to keep it moving forward that way. So I would say that that's probably the first step. If this is something we can either we can wait for a draft. I can, bring a draft, like if that's how the board wants to handle it, and then kind of do it the same way we did it last time, which is, here is a draft. Do you want to support the draft? what changes do you think you have? Or we can start with like, here is a high level, how do you want to handle it? I think it is, there is obviously some, case law with circulators, both at the state and federal level, that make it, I wouldn't say challenging, but you have to consider it, right? There is case law at the federal level from the US Supreme Court that says that a right between a circulator and a voter is speech. There's case law at the state court that deals with a burden being placed on circulating. So I think that there is room to explore things if the board is interested. But I think that would be kind of the first step. Is this something the board's interested in? And how does the board want to handle it? Do you want to draft? Do you want a draft? Do you want to bring it? Do you want just to, what is the board's preference on next steps, I guess, is what I'm trying to ineloquently say.
That was a perfect segue. Vice Chair.
But could we ask our legal counsel to address the question, to make what Member Hauskamp is asking is what kind of regulation of circulator companies is possible? Could we ask you to give us some insight, given what Mr. Fracassi has referred to as both the federal and state determinations?
I will consider that and see what I think might be appropriate from our office.
Yeah, I mean, one possibility would be if there's a draft legislation, there might be a request from the board to council to evaluate potential constitutional challenges to that draft legislation
Right.
based on the case law. Like that way you'd have a more specific question to answer.
That makes more sense.
Are you, within my board members, within the board here, how do you folks feel about, do you feel like this is going down the right road of saying, let's address this by trying to at least put some guardrails in?
I am naturally opposed to what you're proposing.
Yes.
For a number of reasons,
It would be
however,
amusing to let you go on as to why you-
I understand what problem you are trying to solve. I don't necessarily agree that that is the best path forward for solving it. And again, threw a curveball at me today, so I wasn't quite prepared to answer that. But I would say that, look, if at the end of the day, our goal, right, is to make sure that this process is as clean as possible, and that the voters who are putting their names on those pieces of paper, that if they're valid signatures, that they are counted. If we want to look at a process to make that better and make that easier, I'm all for that. Regulating these companies and having them register people. And again, I'm not an attorney, but I can imagine all sorts of First Amendment issues with that. So am I opposed to making the process better? No. Do I think that just having these guys register and putting signatures on, like,
Well, I'm not sure what that would look like either. I think that's part of the whole conversation.
Sure.
Is that if you and I go out and we build a company in Michigan, and I have a few, and so do you.
Yeah.
Right? And we naturally have to register that. We have to register that company. If you hire employees and you put them out to do something, whether it's something trade oriented or whether it's something professional, there's expectations that you're monitoring and measuring who they are.
Yep.
This is a,
And they have those, even if you're just a regular company, they're gonna have those.
but
those
we don't
signatures.
have a way
You're
to
talking about
bring it
hidden-
around here, okay?
Yeah.
And the problem is not listen, there are some outstanding companies who are doing. Mr. Doster, have a wonderful holiday. Thanks for coming. Um, there are companies out there who are doing an outstanding job of putting teams of circulators in Michigan.
Yeah.
To get signatures and representing the voters very well. Those are folks that are not going to be affected by registering their companies because they already have. They're not going to be affected by managing their employees because they already have. But there's a problem here in the folks that are coming to us that are not legitimate. There's interlopers coming from outside of Michigan. I'm using that word carefully, yes. But there are people coming from outside of Michigan
They have the right
Who
to
are-
interlope.
who are, I know, I'm helping out with that. I'm a storyteller, and all that stuff. There's companies coming in here who are bad actors. And they give the good actors a bad name. And to play to what your conversation was earlier, they're an enormous risk for disenfranchising Michigan voters. And it seems as though there's a hole. What would that legislation look like? I don't know. That's not this conversation.
Yeah.
But at the very least, it seems like we could put something in motion here that would start the dialogue. And if I'm hearing the Bureau correctly, we could empower them or we could enable them to lobby on our behalf. Is that?
We can provide technical support, basically. I mean, so we can, if the board wants to pursue a legislative option, we can help with the drafting. We can, provide, as Adam said, subject matter expertise in putting that together. And then we can request the Department of State support it in different capacities. I mean, one way is maybe the Department of State just agrees it's a good idea and wants to support it. Another thing the department can do is, even if the department doesn't have a substantive position on the legislation, they can still, present it on behalf of the board. Basically just provide sort of extension of the technical support that we're providing to the legislature. But we can, I mean, if the board wants to, similar to a couple of years ago, pursue legislation, we can provide technical support there.
One other thing to consider is that this is a problem that a lot of states are addressing. We've talked about that. And there are legislative or procedural efforts in a number of states that we could look at again. I think that would be prudent, that maybe we can get some input from staff and from the AG's office about what other states are doing with regard to circulators. Whether registration of the companies is permissible, what kind of standards could be imposed. I just think, we're not starting in a vacuum, and we can look and see what's going on out there, because it's a national issue.
It is.
So that might be a good place to start. I don't want to suggest that the First Amendment isn't what it used to be, but there's also some question about
Whether it would,
about what kinds of things could be imposed.
well, and again, I mean, the conversations we're having here are you, I know you. This isn't something that someone has to register with the state of Michigan individually in order to go out and collect signatures. Is what the First Amendment issue was about. This is something that simply says if there's a challenge and Mr. Brewer has claimed to gather signatures, we have the ability to find out if Mr. Brewer is really Mr. Brewer.
I mean, if he's a circulator or a
As a
circulator
circulator,
company.
I'm sorry. If we were,
I-
we're giving you a new role.
What I would propose before we do any sort of work is, I would prefer an opportunity to chew on this. I don't disagree with the fact that we have, some issues that seems like they could be solved legislatively. I don't, you know, I want to look at that a little bit closer, but maybe I'm looking at our list of proposed meetings. We've got one in a month.
We have
That should be enough time for me to chew.
Yeah, I agree with you, Paul. This is the first I've heard. So I can't say yes or no, I'd be interested at this moment.
So this is something to consider,
Yes.
and this is something that we can then bring to a meeting in the future, hopefully one soon. Again, it needed to be brought up with you. It was an opportunity to talk with legislature. We've talked before that we can't move forward without legislative help. And in the same token, we keep having these conversations here and we keep ending up at impasses.
But we'll see what happens.
See what happens. You guys noodle on it and then,
We'll see what happens over the course of this busy year reviewing petitions. Our new procedures may really serve us very
you will
well.
be surprised, right?
Maybe.
Okay.
Maybe the quality of signatures will improve dramatically.
We, oh, we also, in your packets, you have a list of proposed dates for 26.
Yes, we do. And these are not to be voted on yet because I think we can't approve them until next year. But just for the board's awareness, these are the tentative dates that we will propose for the board to approve at the next meeting.
And these presumably are based upon all deadlines which we are required to meet, right?
Yes, so there are a number. Yeah, so they're based on a couple of things in general. So we try to always have one regularly scheduled a month. But we also have them based on the certification of the candidate listing and all of that, which is it's in May when the board has to meet. And then I've got the follow-up one in June as a hold in case sometimes what happens, some candidates will go to the court inevitably, and the court sometimes will order the board to say you have to meet and recertify. You've got to meet and do XYZ, whatever it is. So we've got that flexibility built in. It's built on certifying an election. It's based on recount deadlines after November, so that way it's all there. If there are dates on here that you know right now will not work, let me know. And then I can look and see. What works and what doesn't. And I can tell you if you've got questions about specific dates, I can tell you kind of a topic of what will be on that meeting most likely. Or if this is just a regularly scheduled once a month meeting. And then what will happen is we will vote on them. You will vote on them in January at the first meeting, and then it will be posted for the whole year on our website, on the building as normal. And then we still have the ability to call special meetings still too. So it's not like this is it. Like if something comes up, recall petition, for example, if that comes up and it doesn't fit that tight window we have, you still would have the ability to call a separate special meeting.
But you want us to adjust our plans going forward so that we are available on these dates.
Yeah.
Yes.
Ideally.
Yeah, I mean, some specific dates are more important than others, right? So like the ones that are around like the petition, some of the petition deadlines, those are, maybe can move a little bit, but we need to have those meetings. The post-election one, obviously, we need to certify the election. But some of the other ones are more flexible. Like we may even cancel some of those depending if there's nothing on the agenda.
All right, we'll consider those and we'll look at them next meeting. We have one last item on the agenda, or not on the agenda, but under new business, we have a proposed logo for the board.
Yes. Something fun.
Something fun.
So I've mentioned this a couple of times now, but now you have an example. So we are looking at different things with the board to make the board's branding consistent across everything, across the website, across materials, across all of it. So we have developed some examples. It's two examples. There's just one color version, one black and white version. The idea with this is to use this on all materials, and I'll kind of talk about like what the logo and then also where it would go and some of the other stuff that I'm planning on doing after the first of the year as well. So currently, like if you look at the agenda at the top, it's everything's just on board or Bureau of Elections letterhead and things like that. The idea with this is that we would replace all the board's manuals, we would replace all of the materials that go online, everything with it would go to this logo instead of being on the Bureau of Elections. The idea would be just to give everything that consistent. So when you're seeing something board, you know that this is the official Board of State Canvassers material. So that's what we're looking to go with. The other thing we're looking to do with this as well is this has been a request, I know from Vice Chair Gerwitz at least, and I actually think from Ms. Bradshaw, business cards. To have your information on there. There are instances in which board members have, I actually believe with Ms. Bradshaw, where they have shown up at a recount that the Board of State Canvassers is conducting. You are allowed to go to recounts that you guys are conducting. And there have been some instances in which board members in the past have gone and it's county clerks have said, you know, prove it, right? In a nice way, not being mean, but they're doing their diligence, right? As they should be. So this will give you something to be able to say, hey, I am actually a member of the Board of State Canvassers. We'll be able to do that. The other thing that we're going to do is update the website. We've talked about this a little bit before. We are doing a pretty major reformatting of our website after the first of the year. We are going to have it be more, like we talked about previously, like docket focused. If you think of like a court where there's drop downs and all the materials, we are going to attempt to just get to the point where we can post everything online and stop having to rely on bureau staff having to send challenges to folks. It will just go online. Responses go online. So not only does the public get it, but it's another avenue for you guys to get it as well, where you can go to the board's website and be able to get it, but then the public can get it as well, and it saves staff the time from having to go back, do the back and forth, but also just ensures that it went out. If that way we're not as worried if maybe did we miss something? Did we miss sending it to somebody? Everything goes online. And when I say everything, what I mean are like in the petition context, the challenge, the rebuttal, like that type of stuff, that back and forth. We would not post public comments, like citizens that are just voters that are just coming to the board to say, I support X, Y, and Z. I am opposed to X, Y, and Z. I'm not going to post that online because there's information that would have to be redacted to do that. We'll provide it if somebody asks for it, but we redact the personal information. Sometimes people will give us their home address. They'll obviously we get their email address, so we'll redact that information out if somebody wants to. But the materials that are essentially going before the board will go online. We're going to have it quarterly. So we will have the next basically 3 months worth of meetings at any given time on the website. And the reason for that is just pure website stability. They were a little bit worried that if we put the whole year on, that the system would be really slow because of just the volume that you might have, which is actually a little bit of an increase anyway, even on a quarterly basis from what we do now. So we would leave. What it would look like is you'll essentially have a drop down. So it would say, January 1st, 2026, and then it would be a drop down. You'll have the agenda, you'll have any meeting materials that will be on there as well. Then it'll go to the February, then the March, and same thing. We'll keep that up. And then after the March meeting, we'll replace for April, May, June, July, the appropriate quarter, whatever they are. The one going back to the logo, they're basically the same thing. The one difference between the two is the word Michigan. Basically, it's do you want the word Michigan on the outside or not? I have my preference. I've heard from one of you guys and about your preference, but I don't know if anybody has a strong preference. If not, the one I would go with is the Michigan, the one with the word Michigan in there, just to make it consistent, but I don't really have a strong preference. We do have a color version of both of them. I will say it's the color is similar to the rest of the state's branding, but different. It's black and yellow instead of blue and yellow. The reason that we decided to go with black instead of blue in the band was largely because of the University of Michigan. There was concern where if it was the blue and yellow, would that be, would the average person associate this as a board on behalf of the university and not the state of Michigan? So we thought of just keeping the blue out of it for that reason. So that's why the black and yellow is there. I'm not 100% sure whether we would use this. We don't have to. We can use the black and white altogether, but we wanted to have some sort of color option in case we need it. So that's kind of where we're at with some of this. I would say unless there's like strong opposition, I probably will move forward with the first one that you have in your packet with the word Michigan in it. Unless they're like, if anybody's like diametrically opposed. The other thing that we will do is I am going to go back to the documents that are on the board's website and replace this. And just, again, like I said, make it consistent with this. Just that front page and all the manuals has the Secretary of State's like the official department seal. So I am going to replace that with this version as well. And then there will be, like I said, after the first of the year, slight changes in just visually the materials and things like that, not substantively, but we'll change some of the materials after the first of the year, like I said, just to make that brand consistent across the board with everything that you guys are doing. So that's where we're at. Happy to answer any questions or if there's any thoughts or anything.
I like the Michigan
Mhm.
in it, and I don't like the black and yellow.
Very fair.
I'm on board with that too. What do you think? You're good?
Yep.
Ms. Cummings?
Yep.
So,
Oh, this what we're agreeing to here?
We don't think we need a motion, so.
you want to make one, you can, but I don't think you need one.
No. Just,
So,
it's
That
done.
one.
Anything else before we break?
Did Jessica bring us lunch?
We did not.
All right. Wishing you all a very happy holiday season for the folks that are here. Ms. Bradshaw, it's outstanding to see you. And with that, we're adjourned.